Welcome everyone, and thank you for joining us for today's webinar on managing shareholder dynamics and mitigating disputes in business. My name is Maya Ajami from ME Law, and I'm excited really to explore this topic with you. It's very crucial to protecting your business, enhancing stability, and fostering growth among shareholders. I have approximately 10 years of litigation experience. I was born to be in a courtroom. I love being in a courtroom, and I've dealt with every single issue we are going to speak about today and have obtained successful outcomes for all my clients. Today's webinar will cover these topics: importance of early planning, preventive measures, causes of shareholder disputes, crafting strong shareholder agreements, resolving disputes, legal recourse options, and key takeaways, followed by a question and answer period. Now, moving on, so I just want to let you guys know you will be getting access to these slides. We will be emailing everyone these slides after our webinar that has signed up to take part in this webinar. So they're very detailed and they're pretty good slides. So I'm just going to briefly go over some of statistics here. So in today's business landscape, shareholder disputes are more common than you might think and can be really disruptive. In fact, according to a 2022 Deloitte study, nearly 50% of businesses report experiencing significant disputes with shareholders or business partners in the first 5 years of operation. You should keep that in mind that litigating shareholder disputes in Canada is very, very costly. The average cost of a shareholder litigation can range from approximately $100,000 Canadian to well over $500,000, depending on the complexity and duration of the case. And I could tell you, I've seen cases that are, we've dealt with cases where they're very, very minor disputes, but they take in a significant period of time to deal with and have been costly for clients. Okay, now you may think, why is it important for business owners to think about potential shareholder disputes up front? When starting a business, it's natural really to focus on the excitement of new ideas, branding, and market strategies. But one of the most crucial aspects, planning for a potential dispute among shareholders, is really often overlooked in the early stages of setting a business. It really may seem premature to think about disagreements when everyone is aligned and energized, but preparing for potential conflicts from the start is really essential for protecting your business's long-term health. Okay? Planning for business disputes is really important because first, it reduces uncertainty and helps business owners and corporate partners establish clear procedures in handling conflicts. Second, it saves you time and money and minimizes costs and lengthy litigation. If you are not prepared to deal with or do not have any checks and balances in place established in your business, you will need to retain legal counsel to assist on all kinds of conflicts that arise not only from those that arise between shareholders or those that have an interest in the corporation, but also conflicts that can occur internally, such as breach of contracts to issues with employees and so forth. Third, it really preserves relationships and encourages amicable resolutions and maintains a steady, strong business relationship. Fourth, it protects your business interests and ensures that your business can continue to operate smoothly while the shareholders or those who have an interest in the business can deal with any and all conflicts really away from the operational aspects of the business. Fifth, it really enhances the decision-making process, and it provides a framework for essentially resolving issues effectively and efficiently, and overall maintains the stability and focus on business growth. Now, key considerations. Next slide here, we discuss a number of key considerations when starting your business that you need to really be thinking about. First, you need to look at the business structure and shareholder roles. So many business owners don't think about really how to structure their business or how roles of the shareholders will evolve, especially if they start out as a small corporation that is self-funded or start a corporation with limited resources and are now at the scaling stages and they want to really take their business to the next level. Whether you're really starting a business alone and later scaling it to add shareholders, or you're starting the business with others, it is really essential to decide earlier on the structure, ownership, voting rights, and financial obligations. Okay, these decisions not really only influence the daily operations of your business, but also the long-term growth and stability of your business. Okay. Next, you need to consider aligning goals and expectations. When shareholders have different visions, such as focusing on rapid expansion and another on stable growth, conflicts can really arise. These misaligned goals can become problematic really as the company grows, leading to disagreements over spending, profit distribution, and business strategy. Aligning on a clear vision, purpose, and future goals earlier on ensures everyone's on the same page. There needs to be an understanding, okay, between the shareholders that the company needs to be assessing both really its short-term and long-term goals on a regular basis, and needs to be flexible to change the corporation's vision and goals. There needs to be an understanding that many factors affect how well a business will do, and there needs to be an agreement as to what direction to take your company. Okay. However, conflicts do arise, and we see them arise in both corporations that have been around for a short period of time, less than 6 months, and those who have been around for longer than 20 years plus. And not everyone's ready for change and growth, right? This is not what some shareholders want. To really manage shareholder differences, it is important that you have a clear shareholders agreement, there is effective communication, and a dispute resolution mechanism in place. I'm going to be saying that a lot this morning, but it's really important. Okay? In Ontario, where shareholders do have differing goals, expectations, and visions in a corporation, the courts tend to address such issues through the oppression remedy found under the Ontario Business Corporation Act, Section 248. Other similar provincial acts like the BC, British Columbia Business Corporation Act, Section 277, also addresses this. You also have the Canadian Business Corporation Act. It has a section on oppression and so forth. The statutory equitable remedy really is designed to protect the reasonable expectations of shareholders or other complaints, and offers a broad array of potential court orders to rectify the oppressive actions or admissions. Okay? The case law really provides guidance on how the courts determine whether oppression has occurred, and the court must assess really the reasonable expectations of the shareholders based on the existing arrangements and relationships between the parties. Okay? Next, we need to look at defining roles and legal entities. Okay? Registering a corporation, for example, creates a separate legal entity with specific rights, responsibilities, and protections for shareholders. This formal separation helps define each shareholder's role, both legally and operationally, and really helps protect individual assets. Taking the time to understand and establish the appropriate legal structure for your business will really protect both the company and the shareholders from personal liability and prevent complications down the line. A well-drafted shareholders agreement will help any corporation in clearly outlining specific roles, responsibilities, and duties for each shareholder within the company. Without this, you will have issues with shareholders, officers, and directors. If the corporation has multiple shareholders, you want to determine who is responsible for what. For example, one shareholder could be responsible for overseeing the projects, services, or work being done by the company's employees. Another shareholder could be responsible for developing business, and both shareholders can work together in developing strategic goals. They can work together on HR, and they can also work together on the different roles and responsibilities they hold. There also really needs to be steps taken to determine who has the authority to make certain decisions and how these decisions are made. Are decisions made based on need and budget? Who approves the projects the corporation takes on? And how is that approval sought or given, and so forth. Expectations also need to be set. Running a corporation or really starting one is not for the weak. It really involves a lot of risks, but it is rewarding. It is like the sublime and beautiful, really working together in the end and balancing each other out. Now, another consideration you need to think about when starting a business is really exit strategies and succession planning. Really planning for potential shareholder exits, whether due to personal reasons, disagreements, or other factors, is crucial. Having a clear exit strategy from the start minimizes disruptions, ensuring stability and continuity even if there is a change in ownership. Okay? You need clear, defined exit procedures, and this needs to be done by outlining how shareholders can sell or transfer their shares, including rights of first refusal or buy-sell clauses. These buy-sell clauses are really often referred to as shotgun clauses, and agreements around that. Focus should really be on how shares are to be valued during an exit, not just during a buyout, but also how does one determine the value of someone's shareholders if they die while still being a shareholder in the corporation. There should also be succession planning, which can provide leadership with detailed plans on transition and continuity, and in case of retirement, death, or incapacity. Two recent Ontario cases where the court had to deal with shareholder disputes on the lack of succession planning and exit strategies, again turning to the corporate statute and the oppression remedy in order to address the unfair conduct and uphold the reasonable expectations of the shareholders. Okay? And Deteau and Tony Deteau and Sons Limited, a 2019 case, the court addressed the reasonable expectation of shareholders concerning succession planning in a family-owned company. The court considered the principles underlying the oppression remedy, particularly the concept of reasonable expectations, and found that the conduct in question did not justify the winding up of the corporation, but required directives for the company's future operations. And finally, in Vitesse and Comatis 2022, it's a case that involved dispute over the refusal to consent to share transfers as part of a succession plan. The court in this case found that the refusal was unjust and inequitable, considering the context of succession planning and the parties' reasonable expectations. The court emphasized that the conduct disregarding the interests of the complaints could be considered oppressive, even if it did not breach any legal right. So you could see that the case law is really, there's different case law in this area, different considerations, but it all comes down to what the reasonable expectations are for parties. Okay? Now, we turn to the next slide here. So planning for potential disputes has long-term benefits. Okay? Now, it may seem tedious, but it is an investment really in the business future stability and success. It really helps clarify responsibilities as discussed, outline processes for decision making, and set expectations for all parties involved. You really should take a proactive approach to potential conflicts, create a stronger foundation, ensuring that if disagreements do arise, there are clear procedures set out to address them. This preparation can serve your business from the costly, time-consuming of resolving conflicts after they arise. It is imperative that the company continue to operate smoothly and continue to grow despite any ongoing dispute. Okay? By thinking about these factors before the issues arise, you're setting your business up for smoother operations, better relationships among stakeholders, and ultimately greater success. Now that we understand how important it is to anticipate potential conflicts, let's explore strategies for preventing these disputes altogether. In the next section, we will look at preventive strategies for avoiding shareholder disputes. Okay? First, you need to understand what causes shareholder disputes. Okay? In order to prevent shareholder disputes effectively, it is essential to really understand the most common causes of these conflicts. Shareholder disputes can arise really for a variety of reasons, whether it's a difference in vision, disagreements over financial management, or even personal issues that really impact the business decisions. By being aware of these potential triggers, business owners and shareholders can address issues earlier on and take proactive steps to maintain harmony within the company. First, you need to consider the best interests of the corporation. In simple terms, directors or officers of the corporations can face allegations of breaching their fiduciary duties and not acting in the company's best interest. For example, directors or officers have fiduciary duties, which include the duty of care, which means they must make informed and prudent decisions for the company. They have a duty of loyalty, which means they must prioritize the company's interests over personal gains. They have a duty to act in good faith, which means that acting honestly and with integrity. And directors and officers have a duty of obedience, which means they have a duty to comply with the laws and corporate governing documents related to the corporation. The second area that tends to cause shareholder disputes is really a lack of shareholder agreement, right? So if there's no shareholder agreement, or there's a poorly drafted shareholders agreement, there will almost always be an increased number of disputes. Without clear guidelines, conflicts among shareholders are most likely to occur. There are unclear roles and ambiguity in the roles, and responsibilities can lead to operational inefficiency. So you are also left, the businesses are vulnerable really to misunderstandings and conflicts that could otherwise have been avoided. A next area that you need to think about, which you need to look at in terms of what causes shareholder disputes, is really a lack of communication. This is a big one, and it does lead to shareholder disputes when there's a lack of communication between the shareholders. There's an increased misunderstanding, which leads to misinterpretations or intentions and actions and so forth. This can lead really to ineffective decision-making and delays in really reaching concessions on important matters, which are significant, which can significantly impact the business operations and really disrupts the focus on strategic goals and daily operations. Okay. Next area that you need to look at is really the misalignment of goals and growth direction. Now, as already stated discussed, there could be different goals and visions for the company growth. So one shareholder might want to expand rapidly or take the business to a new direction, while another prefers a more conservative approach. This misalignment of goals can lead to disputes over strategy and investment. And then, especially if shareholders have differing levels of risk tolerance, defining and really aligning your business goals early on helps prevent these types of conflict. When there is a misalignment of goals and growth direction, the shareholder disputes arise in a sense that there are strategic conflicts, and these revolve around disagreements on business expansions, mergers, acquisitions. It could be a problem when it comes to determining what resources are allocated where, and differing opinions on where to invest your time and money. So priorities really need to be shifted when there is a clash over product development or market focus. Okay. Another thing you need to look at is financial mismanagement and fraud. These can cause significant shareholder disputes, and in some cases can dissolve a company, even one that's been around for a long time. So you might, as a shareholder, sit back and think, oh, wow, we did so well this year, but where's the money gone, right? The company then has to spend a significant amount of money hiring forensic accountants to review accounting documents and having to trace that money, and having to get the police involved, for example, if fraud is involved, to having to go to civil court and so forth. Then you have distrust really growing within the company when allegations are made against individual shareholders related to improper use of company funds or assets. And just on a side note, really, guys, financial mismanagement or fraud does not only necessarily involve at the shareholder level, but it can also be on the management and employee level, right? So fraud can occur on both the management side and employee level, what's often termed as occupational fraud. There are issues over accountability and who's responsible for the financial oversight. Okay. A next area that you need to consider is really a poorly drafted shareholder agreement. This can also lead to ambiguities because the terms are unclear and it can cause misunderstandings to in terms of the terms and responsibilities, and disputes do arise. If there's inadequate protection in a poorly drafted shareholder agreement fails to protect minority shareholders or address key issues. Okay, for example, a poorly drafted buy-sell clause, which I already told you guys refers to a shotgun clause, can be poorly drafted in that it favors one party over the other, which can create inequality between the shareholders, and it can be seen as oppressive. Okay, a poorly drafted shareholders agreement can lead to inflexibility and lacks provisions for changing circumstances or business needs. This also leads to higher likelihood of legal disputes that can arise and an increased litigation due to unclear or incomplete terms. Right? We are a litigation law firm, so we do see a lot of these, issues where shareholder agreements were drafted. They were drafted poorly, and we got to go to arbitration or to court to actually interpret them, and so forth. But it is really imperative that you do have a lawyer who really specializes in drafting shareholder agreements to assist you. I have litigated matters, as I mentioned, where an arbitrator is being asked to determine the validity of specific clauses in shareholders agreements. Okay. Now, another area you need to think about, really, as I already mentioned, personal clashes and personal vendettas can lead to shareholder disputes, right? And these serious conflicts do arise when personalities clash, and one shareholder might have a personal vendetta against another shareholder. These disputes often lead to emotional decision making, decisions that are really driven by personal feelings rather than business interests. And if there's an increased tension and heightened conflicts, there is hostility among shareholders, and this can create a hostile work environment. Shareholders are really often sometimes distracted from their business goals, and their focus shifts away from strategic goals as it becomes difficult to reach any kind of resolution due to their personal biases, and this can cause significant damage, as I mentioned, to company culture. Okay, and again, if you can have a separate corporate lawyer that strictly represents your corporation, and there are instances when their actions have to be brought to force the shareholders to do something in the best interest of the company. Okay. Now, another area that you need to think about is varying risk tolerance and investment philosophies. Okay. Disputes really can arise in terms of strategic conflicts, in terms of disagreements in business directions, as I already mentioned, and investment decisions, financial tensions, and really different views of spending, saving, or reinvesting the profits earned. There can also be decision-making gridlock, and the parties are unable to reach a concession on key initiatives. Again, this impacts the company's stability. So the main thing that you guys all have to think about is really the corporation's interests have to be forefront in any kind of dispute. If you have a long-standing corporation and you intend to keep that corporation going, you really have to move this dispute away from the day-to-day operations, and you really have to come to there has to be an expectation that the shareholders will deal with this dispute outside of the operational aspects of the business. Okay. Because you don't want your product, if you're producing product, you can't just stop. If you are selling houses, you can't just stop. If you're providing a service, you can't just stop. Like, there has to be things set up where that continues, the operational continues, clients are being served, products are being produced, and the shareholders are on the side dealing with the dispute. So this is where corporate governance comes into play. So it's important that you have clear corporate governance and you have clear management roles and responsibilities. I know it might be difficult in a smaller company that's just started out, but it's something you need to think long-term in really growing and investing in as part of your company. Now, again, as we talked about, there's lack of clear exit strategies, which again leads to disputes. Okay, so now we're going to look at another area that leads to dispute, again, as profit distribution and reinvestment. So you might have issues in terms of returns and future growth, and issues arising as issuing new shares to raise capital, affecting ownership percentage. Again, there needs to be clear communication, and there needs to be about these financial decisions that need to be taken. Then you have disputes over share valuation, right? This is a common area. Usually when a dispute does arise in this, it's always wise to hire an expert, an agreed upon business valuator who can take steps to evaluate the business, since there's going to be disputes between the shareholders in terms of how the shares in the corporation are valued. And since there are almost always major disagreements on this approach used to value shares. If there is a conflicts that do arise over what is considered the fair market value shares and what constitutes the fair price for the shares, once you determine the value of the shares, then it's easier to negotiate a buyout, okay? As already stated, disputes can also arise regarding the terms and conditions of a buyout. So, at this point, it's better to retain, when this issue does arise, litigation counsel or counsel to assist you really in all your disputes that's working in your interest as a shareholder, because litigation counsel or any counsel you decide to use would be able to assist you, not only helping select a valuator, but also on when valuation should be conducted. Okay? Another area that's not on the slide is leadership disputes. Really, as the business grows, disputes can really start arising regarding the leadership roles, especially if one shareholder assumes more active role in management. Planning for defining these roles really and planning for them in a shareholder agreement can really prevent conflicts. And I will discuss a little bit later on in terms of how a shareholders agreement is a living document and needs to be reviewed annually. Okay. Now, a major area that really leads to dispute, and it's maybe 90% of what litigators in this area tend to deal with, is minority shareholder oppression. As I alluded to the corporate statute, these are made really by shareholders, and there are related to the fact that the minority shareholders are excluded from or prevented from making or taking part in decision-making process related to important decisions that have to be made for the corporation. They can bring claims of oppression if they are being denied, for example, access to information. So if one shareholder is withholding financial or operational information, this can lead to significant disputes. Shareholders have the right to access all books and records related to the corporation, and this is clearly outlined in the corporate statute. Other actions taken by shareholders that can also lead to oppression, including creating unfair dividend policies, creating and implementing policies that disproportionately benefit majority shareholders over minority shareholders. Okay? Now, the importance of strategic alignment, basically, it's really important that you align strategic goals. So a corporation's direction is often planned out years in advance, right? With long-term strategies for growth, market expansion, and profitability. When shareholders do agree on these goals, it disrupts really the business's forward growth. So it's really crucial that you think about the company's future and you plan strategically based on that, which helps avoid conflicts, right? Because you always have, if you're a very niched company, you're breaking into the market, and as soon as you start, you have a dispute, it's really going to be a setback, right? It's also prudent to seek professional guidance, okay? So when your business doesn't encounter complex issues, whether financial, legal, operational, you should be working with legal and business consultants, right? And I say this is very, very important. So you need to look at, for an experienced, for example, lawyer can help you mitigate conflicts and offer their insight, and you need, which can help keep the company moving forward in the right direction. There's also important areas you need to consider, like corporate governance, where specialized knowledge is really needed to navigate your shareholders' rights, fiduciary duties, and regulatory compliance. So, you want to set up an HR department, right? You need to find somebody who's skilled, a consultant who's skilled in HR, setting up an HR department. You need to hire the right people to manage that area or to run it. And, you need to make sure that all that complies with the laws, okay? The changing legal landscape, okay? So, so you not just lawyers, okay? Other people, okay? So you need to think about what type of consultant you need to bring into your business to help you grow it, okay? And help you manage it and ensure it stays on the right track. Now, shareholder agreements. So I'm just going to briefly look at this because it's now important that you have a shareholders agreement, which is the most effective way to really prevent any disputes and mitigate litigation risk. So a well-drafted shareholder agreement is more than just a legal document. It's a strategic tool that governs how shareholders interact with one another and how their business is managed. It serves as a preventive measure, ensuring that disputes either are avoided entirely or dealt with effectively when they do arise. So a shareholders agreement, it does serve as a guidebook and how the company will be governed and how key decisions will be made and how conflicts will be arise, as already stated. So first, you should have clear definition of roles and responsibilities in the shareholder agreement. Second, there needs to be a structured decision-making process. Third, there needs to be conflict resolution provisions. Okay. 4, there needs to be transparency in financial matters. Okay. Now, what do you do if no shareholder agreement exists? Okay. For businesses that are currently operating without a shareholder agreement, it's really crucial to prioritize drafting one as soon as possible. In the absence of a formal agreement, consider creating an interim agreement to cover immediate essentials, such as decision-making processes, voting rights, profit distribution. Consulting with legal counsel at the early stage can be invaluable in developing a foundational shareholder agreement that addresses the company's needs and future goals. Starting with even a basic agreement now can prevent significant challenges and expenses down the line as the business grows, right? Now, a strong shareholder agreement should cover several essential areas to protect the business and ensure stability. These clauses are tailored to specific needs of the company and the shareholders, okay? Now, first you need to add this shareholder ownership and transfer clause. So this really revolves around rules for buying, selling, transferring shares, including rights of first refusal, help managing ownership transactions smoothly, and really prevent disputes over shareholder exits or ownership changes. Then you need to also include clauses around voting rights. These really define how shareholders vote on significant company matters, such as electing directors, approving major transactions, amending corporate documents, and issuing new shares. These are typically proportional to share ownership, but may vary depending on the class of shares you have. Then clauses related to dividends, so policy on dividend distribution, ensuring clarity on how and when profits will be shared among shareholders, minimizing conflicts over financial expectations. Board composition, okay, guidelines around appointing, removing, and defining the roles of directors, helping structure leadership in a way that aligns with shareholder interests and corporate governance standards. You have confidentiality clauses, the obligations to restrict shareholders from disclosing sensitive company information, safeguarding the company's intellectual property and competitive advantage, non-compete clause. If you do have a non-compete, non-solicitation clause, and it's fair in duration and terms, the courts are more inclined to agree that they are enforceable. So keep in mind that if such a clause is to be drafted, it is beneficial for, i.e., all the parties, not to use, for example, a similar name, not to compete for a year, not to solicit clients, etc., that it's drafted in a way that is fair. Okay? Now, there is case law that just came out in this. Specifically, there's a case that came out in BC where the court found that among the shareholder in that company, the non-compete, non-solicitation was fair. Okay, so especially if you're a shareholder, courts are more really inclined to also allow for these clauses to be included. Okay, so because you really want to protect the company's position and interest, right? Exit strategy, again, we talked about that. If the shareholder wants to leave, what will happen to the shares? Is so far buy, sell, right of first refusal. So all that stuff is important. Then you want to also add clauses related to funding and capital contribution. So this clause typically defines any additional funding or capital contribution required from shareholders to ensure financial alignment and commitment to the business growth and stability. And you have rights and obligations in there. So rights and duties and obligations of shareholders. Really, this clause should be customized to fit the company's unique needs, okay? And help clarify the expectations and really promote a cohesive shareholder relationship. Okay? Now, treating shareholder agreements as living documents. Okay, so this is very, very important here, okay? A shareholder agreement isn't something you draft once and forget about it, okay? So you can't rely on a shareholder agreement you drafted in the 70s, for example, right? As your business grows, the laws evolve and your business evolves, so must your shareholder agreements. There should be regular reviewing and updating of your agreement. It's essential to really ensure that it reflects the current operational and future goals and legal requirements. Here are key scenarios when updating your agreement is crucial. First, I do apologize. Let's go back. First, when you're acquiring or merging with another business, the shareholder agreement should be updated to incorporate new shareholders and address any changes in structure. Number two, when there is leadership changes in leadership, such as appointing a new company CEO or board member, may require adjustments to governance clauses and decision-making protocols. Significant financial milestones is a third one. Okay, major funding rounds, expansion or profit milestones may promote revisions to profit sharing or capital contribution clauses. Then another area, as I alluded to, regulatory changes, legal updates to corporate or tax laws, as well as if you're a specific company that has certain regulations, you need to make regular legal reviews for your shareholder agreements, and it's crucial that you do that. Now, if you treat your shareholder agreement as a dynamic document, your business can adapt to changes and ensure that agreements continue to serve the best interest of the company and its shareholders. Okay? Now, what do you do when a shareholder dispute does arise? Okay? Now, having a well-drafted shareholder agreement is one of the most, as I said, effective ways to prevent disputes and minimize litigation risk. It sets a strong foundation for managing shareholder relationships and really adapting to the company's growth. Now, what do you do if disputes arise? Okay, you should, despite taking preventive measures, because even if you create these policies and procedures and you have everything in place, there is going to still be issues and disputes are still going to arise. So, when a shareholder dispute does arise, it's crucial to act quickly and thoughtfully. Okay, mishandling the situation can escalate conflicts even more. They can hurt the company and it can impact the relationship within the business. Okay, here are the immediate steps to take if a dispute does arise and how you can handle effectively and professionally. First, you should contact legal counsel. You should contact ideally legal counsel with expertise in corporate law and shareholder disputes. So corporate litigation, shareholder disputes, corporate law. An experienced lawyer acts not just as a legal representation for you, but as an advocate, ensuring that your interests are protected throughout the process. You could hire a separate legal counsel too for the corporation to ensure that the corporation's interests are being handled and are effectively represented. A legal counsel can provide you an objective assessment really of the situation. They can advise you of your legal rights and guide you through potential outcomes. Having outside counsel who understands both the emotional and financial stakes is essential for managing the complexities of shareholder disputes. Okay? Second, you need to evaluate the situation and consider the liability. Okay? Once legal counsel is involved, assessing the extent and the nature of the dispute. This may include obtaining independent valuation of shares, particularly if a shareholder wants to sell or exit the corporation. Evaluation provides an objective basis for negotiations, and it ensures that it offers or buyouts are based on accurate market value. So valuations differ significantly. Consider hiring separate valuators for each party. If it's a two-person shareholders in the company, okay? Knowing the value and the liabilities at stake really helps in negotiation and setting realistic expectations for both parties. Third, you want to engage in communication with the other parties, okay? Keeping in mind, you need to keep the communication channels open, ideally through legal counsel. This is really key in preventing escalation in your disputes, okay? Because disputes can be emotionally charged, okay? But you have a professional in there really helping you unpack and getting down to what the issue really is. And you have a professional who's communicating your position, who's communicating what the issue are that you're really dealing with, or the shareholders are dealing with, and is able to communicate that effectively. You're more likely to come to a resolution that really is favorable to you and, essentially the other side's happy about. Okay, so there needs to be somebody who really understands and gets down to what your issue really is about, okay? And is able to effectively communicate that for you. Now, exploring, so let's say a conflict does arise, okay? Or you want to really prepare for a conflict should it arise. You need to really explore the different dispute resolution methods that are available for you, okay? Or available for your corporation, okay? The first area you can use to really help with any disputes that arise is mediation. So mediation is really a cost-effective private method of resolving disputes. In mediation, a third party is usually brought in, and the third party and the mediator will assist in both sides in negotiating an agreement. Sometimes a mediator could be, corporate counsel, for example, or could be, a lawyer that's been around and practicing for over 50 years who knows this area really well, who can assist the parties, okay? Or it could be from mediation roster, right? You pick a roster there, you pick a mediator, and you both can deal with the mediation, right? So this informal structure allows flexibility and can help parties reach a resolution without requiring a court decision. It is especially useful for preventing business relationships, right? So you want to preserve business relationships. It encourages open communication and compromise. If mediation does fail, parties can still proceed to arbitration and or litigation. 99.9% of shareholder agreements have arbitration as a dispute clauses in them as a form of a dispute resolution. It is a more formal dispute resolution method, okay? It is the same as if you were going to court. So you do have, you do a notice, you do prepare, you have affidavits or statements, what they're called. You do get cross on them, you do make legal arguments, but it uses an arbitrator, and it's essentially done outside the court. So it's a private judge will usually also be part of it if you decide to pick a judge to do your arbitration. So the arbitrator will hear both sides. A retired judge, not a standing judge, okay? The arbitrators will usually hear both sides and makes a binding decision if that is what is stated in the shareholders agreement, okay? Now, if there's no shareholder agreement and you want to do arbitration, you have to get consent from the other party that they agree to taking the matter by dealing with the matter by way of arbitration. You also have to get consent in terms of what jurisdiction the arbitration would have, because a shareholders agreement will tend to say that the decision made by the arbitrator is final and binding. So you need to agree to all that if you don't have a shareholders agreement in advance. Okay, it is faster generally than litigation, but it still can be costly. Okay, and you need to consult legal counsel to really determine if arbitration is suitable for your specific dispute. Okay, the area that you can also go to is the court action. As I mentioned, you could bring your corporation could bring a derivative action. You have to seek leave from the court to do so. You also can bring, like I said, oppression claims. You can also bring oppression issues to arbitration as well. Again, it is costly, it is lengthy, but it might be necessary in severe cases. For example, those involving accusations of fraud or breaches of fiduciary duties. You have to get a court action if you want an injunction to stop from something happening. Court actions are legally binding and enforceable, and they offer a definitive resolution. You need to consult really with legal counsel to ensure the case is strong or aligned with corporate statutes such as the Ontario Business Corporations Act, BC's Corporations Act, or other provincial laws of Canada or the Canadian Business Corporations Act. Okay, so I'm gonna show you the slide. You will get the slide, but again, considerations when deciding what dispute resolution method you want to use. Really, you need to look at cost and time. You need to think about the privacy, and you need to think about the binding nature and the finality. Okay, now by following these steps, okay, securing legal counsel, evaluating liabilities, and choosing the right resolution method, you can effectively manage shareholder disputes with minimal disruptions to your business. Now, let's summarize key takeaways from today's session and discuss practical strategies for maintaining shareholder harmony in the long term. Okay? Sorry about that. We didn't look at this, but anyway, this is another thing you need to consider. Legal recourse for resolving shareholder disputes. Okay, so again, you're gonna get this slide, but again, there's civil actions, the breach of fiduciary duty claims, there's derivative actions not included on the slide here, there's breach of shareholder agreements, there's injunctions, and worst case scenario, there's you ask the court or you have to dissolve the business. Okay. Now, key takeaways that you should be thinking about really. Review your shareholder agreement annually, right? If not annually, try to do it quarterly. Okay, and also every time you guys are deciding to get more funding, adding more shareholders, you should review your shareholder agreement before doing so. You need to establish regular communication practices, okay? And you do need to create a conflict resolution protocol, okay? Now, thank you, everyone. Let's open it up for questions. Okay, so I see there's a question posted by AD, which states that how often should a business revisit, update shareholder agreement, and what changes typically promote a review? As stated in the slide, and I answered that through the slides that we had. Really, like I said, annually or quarterly or every time there's a change, when there's new shareholders being added, when there's new finances you're looking to get. Really, it's important to review it, okay? You got to look at it this way. It every time you think, I'm a business owner. I take it a lot of people here are business owners that are watching this. Every time you think that you want to grow your business and create a specific, let's say, departments or add more funding, you need to review your shareholder agreement, okay? If you have shareholders in your business. If you intend to bring on shareholders, you need to review the laws. You need to sit with a lawyer to draft a shareholder agreement that takes your type of business into consideration. For example, you are a business that relies on investments, right? To develop, let's say, you're developing a clothing line or you're developing a software product. You need investors, right? That's how you get capital and funding, right? So you need to get in touch with a lawyer who knows about investments, who has done shareholder agreements, for example, related to that type of business, right? So you need to always be thinking about, will a new shareholder agreement be proper for my business, or will a shareholder agreement that I intend to create have the specific rules and regulations related to the product or service area, a product I produce or service area I offer. Okay, so it's very important to take those into consideration. It's not just go draft a normal shareholders agreement or a typical boilerplate shareholders agreement and that's the end of it. No, okay, I've dealt with shareholder agreements that are drafted by lawyers who specialize, that are purely drafted by lawyers who specialize in drafting shareholder agreements. Okay, so it's really important that you work closely with a lawyer who knows your industry and who knows what you need in your shareholder agreement. Okay. Any more other questions? Okay, if that's it, we are litigation lawyers here. We do corporate litigation, we do commercial litigation. I believe just follow us here on ME Law. Okay, we have social media. We do produce content, great content. We have white papers and blogs that we produce on a daily basis. We also have a YouTube channel, so we like to inform you about different areas of law that we offer in the firm. Please follow us on LinkedIn, Me Law Toronto, on X, Me Law Toronto, on our YouTube page, Me Law _litigation_ Me Law Toronto, Instagram, Me Law Toronto. Reach us out, melaw.ca. Also by email, intake@melaw.ca, and our phone number is 416-923-0003. Thank you everyone for joining us today. I really appreciate it, and I look forward to speaking to you soon. Thank you. Oh, I have a question coming in. When partners have disputes in bank, supposed to be informed? Again, yes, I would say the bank has to be informed, especially if there are a dispute regarding access to documents. I would say that the bank has to be informed, and or typically what usually should happen is that the two shareholders, if they're 50% owners in a company, they should be both speaking with the bank and dealing with the bank. It shouldn't just be one person, okay? Especially if it's a dispute. What needs to happen is you need to protect the banking records related to the corporation, okay? You don't want those going out. You don't want those going out to other people, okay? You want to make sure that those banking records are protected, and they're protected in a sense where your competitors are not getting access to them. Okay, so when a dispute does arise, it becomes questionable as to why somebody is going and taking banking records that doesn't really that, you know, especially ordering, let's say, banking records that are a significant period of time, you just don't do that. Okay. So I would recommend, I take it it's Miss Raza. I would recommend Miss Raza really to reach out, because reach out to speak to us and speak to me, because those are specific legal questions that I really don't want to answer publicly. But you're more than welcome to reach out to me, because in that case, it looks like you do have a shareholder dispute, and you need to be addressing this first thing. Okay, it does appear to be a significant shareholder dispute, and I think that we need to be dealing with this. Okay. Thank you guys. This will be posted on the YouTube channel. We will post it. I hope you guys enjoyed our show. Thank you very much. Our webinar, sorry.